Let's talk about the Pennsylvania decision. Stickman is his name. Stickman IV.
That would be my favorite choice for Supreme Court nomination. Just based on that decision, bring Stickman up to the bench.
So this is the decision for anybody who doesn't know. It's William S. Stickman IV out of Pennsylvania dealing with Governor Wolf's lockdown orders and gathering measures. There were two orders in particular they were dealing with. We all know what's going on all over the world. Every state basically has implemented some variation of the same egregious lockdown orders. Brought before this federal judge, he overturned them in a decision which it was from a human perspective, it was a beautiful decision to read because setting aside legalese, which we're going to get into, it was common sense what he said in the decision. He says this is, but for what we saw in China, never in a million years in a free, civilized society would this be, something we would think of adapting. These extensive lockdowns, draconian measures, shutting down business, shutting down the economy as though it's something you can, turn on and off with a switch. And he goes into it, he says, it's not just that we never would have thought of these things. There's no rhyme or reason, even among the minds of the elected officials and the committee members who are implementing it and determining this policy. At one point, he's talking about Pennsylvania says they're shutting down all non-life sustaining businesses. And then, there was a deposition of, I think it was one of the bigger people who reported to the governor. They said, how did you guys decide what was a life-sustaining business, life-sustaining? And he says, well, we didn't really think of a definition. We just went with whatever the committee felt. And this is how they decided to implement draconian measures, anti-democratic measures that will have crippled a generation. So this judge comes down with a great decision and basically says, determines the level of scrutiny to apply to these constitutional decisions. Ultimately says none of these were narrowly tailored. They were, I want to say like killing a fly with a sledgehammer, except someone rightly pointed out it's not. You can't kill a fly with a sledgehammer because you just can't do it as a matter of science. But they implemented these policies which were not narrowly tailored, were willy-nilly, were implemented very politically. The judge pointed out, he says, you've limited public gatherings to 250 people, and yet the governor himself is at a public gathering of 10,000 people, over 100 times bigger than what he himself set out in his rules. None of it makes any sense. Declaratory judgment, it's all unconstitutional. I think that's a good enough summary. Now, the first question people were asking, what does it mean? Okay, so the judge says it's declared unconstitutional. What does that mean? Are they immediately declared invalid and inapplicable, or are they valid for a certain period of time? Like, what does it mean concretely?
So once you get declaratory relief, once a court has said, here's what the law is, or here's what action is legal or not legal, then you can, if anyone tries to enforce that, you can seek remedy by getting contempt of court sanctions against the governing officials. So it means that those orders are invalid in Pennsylvania. And so now there's some argument about prior decisions in different district court judges that allowed it to happen. Doesn't really matter. And the way to think of this is to compare it to all the Trump cases where, two judges may have said what he was doing was fine. One judge said no and issued a nationwide injunction. That decision trumped the others, even though it wasn't quite supposed to happen that way, but that's how it happened functionally. So once a court says this is unconstitutional, you risk contempt if you try to enforce it. So I take it that all of those lockdown rules are no longer in effect in Pennsylvania legally, and so now the degree to which the government acts on that affirmatively there may be some time lag, and they'll probably try to seek a stay of the decision, and then we will definitely likely appeal it, though they shouldn't, because it's the kind of fact pattern that's very, very favorable and friendly to our side, what I would call my side, whatever that is, the anti-lockdown side, because his decision was very well thought out. It was 66 pages long. He developed a detailed factual record, which was not present in almost any other prior case that has gone through this. An extensive discovery, extensive testimony, extensive trial record. And it was what I wanted to see happen. So I'd been telling people early on, pick small issues, because any other issue, the courts are going to say an emergency exception applies and they're going to make bad law. So pick some place where it's really crazy, where they've done something, and focus on that. I brought 4 cases like that. They folded in 2 of them, and I won they folded in 3 of them, and I won the 4th. So I didn't get to run up the flagpole because they were smart enough to not risk it and not appeal any decision that went my way. Now, some other people rushed other decisions up to the food chain, and we got bad rulings out of the Supreme Court. Now, I know I was watching the debate between uncivil law and Nate, and uncivil law does have the better of the argument, in my view. I know where Nate's coming from. It's how the decision was interpreted by some lower courts. But the Supreme Court actually hasn't issued a written, published, precedential opinion approving the lockdown. What they've done is they've denied emergency injunctive relief, where Justice Roberts has written sole concurring decisions, being I'll save the language for later. Whatever reason he may have had to write it, he wrote, basically said Jacobson is kind of the direction here, but he did so in a classic Roberts hedging all of his bets, fuzzing all the ground kind of way. So we don't have a U.S. Supreme Court decision, but it is the case that all we have is the U.S. Supreme Court refusing to give relief, for which one justice explained why. But that's not considered precedential published binding decisions. But appellate judges like Barrett have treated it as such. And Barrett loved that decision. I mean, Barrett, there's no better distinction than reading the Seventh Circuit decision against the Illinois governor versus the decision that came out of the Western District of Pennsylvania with Judge Stickman. And note, by the way, life histories. Unlike Barrett, who comes from a very privileged, protected background, Judge Stickman did not go the judicial clerkship route. Judge Stickman did not go the corporatist route. He comes from Pittsburgh, from Middle America. And so even though he's been on the business side of the equation, he's rooted in Pennsylvania, and he writes like he was very, very smart. Went to Duquesne Law School, I believe, was towards the top of his class. So he's a very bright guy, but not an elite law school. So he has practical intelligence, functional intelligence, not just abstract intelligence. Ben Shapiro has abstract intelligence. God bless him. I wouldn't hire him for any case I ever needed anywhere in the world, because he doesn't have practical experience. He doesn't have life experience, particularly as it relates to the law. So and so that's where Stickman's ruling was fantastic. When I was up at Hillsdale, aside from getting to meet with the Attorney General, who I was very complimentary of course. I might have made a point or two, but that's for another story, another day. But the next day I was up with Alex Berenson, and I made a presentation. I think Hillsdale included as part of their constitutional law series, but it was all based on Stickman's ruling, and it was the background that went into that with what I call the trilogy of infamy, the Jacobson decision, which they brought back from the dead, to resuscitated that horrendous zombie corpse of a decision that said, governments can do whatever they want as long as they say the magic word emergency. If you ever want to study what happened to Nazi Germany and how it could rise to power so easily, study the Weimar Constitution, which was then celebrated as one of the great liberal democratic constitutions of Europe. And its great weakness was it had an emergency exception in it. You could suspend constitutional liberties during an emergency. In the late 1920s, that's precisely what happened when the corporatist government wanted to cover up for their pals when the stock market crashed. And it's what delegitimized that part of the government, and legitimized because Hitler would use it as his grounds to seize power. That's why our founders, even though we went through 7 epidemics between the time of the revolution and the time of the Constitution passing, didn't have any virus exception, pandemic exception, or emergency exception of any kind in the Constitution. But what was also great about what the judge's ruling does, he goes through the whole legal history. He goes through the legal standard. And for those people that don't know, there should be one legal standard, but unfortunately there's 3. So we have something we call rational basis review. And that's the lowest standard. And what basically that says is we're going to say that the law is legal, or your actions are legal, as long as it has any rational nexus to any legitimate public policy. I've never been in favor of that standard because I think that standard invites substituting the judge's opinion for the politician's opinion. I think it doesn't achieve anything in the end, but that's the lowest, very deferential opinion. Very few laws are ever struck down as lacking rational basis. The next level, called intermediate scrutiny, doesn't change the necessity. So what they'll say is that you have to have it has to be narrowly tailored. That's the first part. Both intermediate scrutiny and strict scrutiny. And here, again, what's happening is the courts are looking at what the government has done and saying, okay, why did they do it? And was their remedy proportionate to the reason? And if it's rational basis, it just needs to be any proportionality between policy and reason for the policy. Intermediate scrutiny, it still needs to be narrowly tailored, but it can simply be a lower level of public interest. It can be just a substantial public interest. Whereas strict scrutiny, which is the one I think should apply in all contexts, is the government needs, whenever it's infringing on any core liberty, it needs to have a narrowly tailored remedy to a compelling public policy. And so they just change what weights they give the public policy and the proportionality of the policy in terms of the standards. It invites all kinds of abuse of discretion, in my view, because ultimately courts come up with their own definition of what all those words mean, and it happens to usually align with their own political preferences. That's why I prefer just one standard that everybody can agree on and stick with it.
And just to explain this, so maybe I'll dumb it down further just in terms of the language. The strict scrutiny applies when you are infringing on a core constitutional principle, but you can apply the lower level of scrutiny if there is deemed to be a compelling governmental interest. And so I get
no, it's more what happens is, so if the government is infringing on a core freedom, then generally strict scrutiny has to apply. If instead they're infringing on a freedom, but it's not really a core freedom, then intermediate scrutiny applies. And what changes is not the narrowly tailored part, but what changes is the interest no longer has to be compelling. It can be just any substantial public policy interest. So it goes from, it can be any reason that any legitimate government could have, to a good reason, but maybe not the best reason, to the best, most compelling reason. And so and then the other part is the narrowly tailored part, which applies to both intermediate and strict scrutiny, but doesn't apply to rational basis. Okay. And so they give the easier way I explain it to people is the courts give less deference to the government the more they're hurting people's core constitutional rights.
Okay, so I mean, that's the interesting thing now. So if this decision gets appealed, I mean, I guess first questions first. In your opinion, did the judge get it right on the level of scrutiny to be applied to these measures?
He got it absolutely right, because he explained why intermediate or strict scrutiny could apply. He said no matter which one did apply, he would strike down the laws. He even noted that to a certain degree they didn't even pass rational basis, so that he covered all of his bases. But I think he's right that strict scrutiny should apply in most of the contexts, and that's what he said. He said under even intermediate scrutiny, I still find that this fails. And the good thing he did is he not only went through the whole legal history, he also went through the whole factual empirical history, which has been missing from all these other decisions. He also wonderfully took apart the logic of Jacobson and how, I mean, here's the reality for folks. Jacobson has hardly been cited at all for like half a century. For many people didn't think Jacobson was the law. They've resuscitated the zombie of Jacobson because it's basically said, we as a court system will ignore anything you're doing as long as you use the word emergency. And after the trilogy of infamy is Jacobson, then the Buck decision, where the Supreme Court used the Jacobson decision to say it's okay to do forced involuntary sterilizations of poor women. And we did that. We did it to over 100,000 women in this country, almost all of them poor. The Buck decision is one of the most morally, legally horrendous decisions ever issued, but it relied on Jacobson for its authority. And then the third in that trilogy of infamy is, of course, Korematsu, which again cited Buck and Jacobson as the basis for it. But after Korematsu has become to be so discredited in the legal and historical academy, that's why they didn't talk about Jacobson anymore. They didn't cite Buck, by the way, which is because they would know how bad that would make them look. But Judge Barrett, being the hypocrite that she is, didn't talk about any of that in her Seventh Circuit decision. She acts like, of course, Jacobson has been the guiding light. Whenever there's an emergency, the government has whatever power it wants. It just has to declare the emergency. We don't even get to empirically check on whether they're right about whether an emergency even exists. It's just a unilateral declaration of emergency. And what he did a great job of doing was saying, look, by the way, when Jacobson was decided, it was a whole different jurisprudence that applied. We didn't even have strict scrutiny then. That almost all of the logic that was applying by the court at that time, which basically was saying that the Constitution didn't even apply to the states mostly. They weren't enforcing the 14th Amendment back then at all. unless you're a big corporation, then they found compelling cause to do so. The railroad rule, as my torts law professor used to say, which is that whichever side the railroad is on, the railroad wins. There's a lot. Look through American legal history from 1870 to 1920, you'll find a lot of that. But based on that, Jacobson, it was his bad law. It's been overturned effectively, implicitly, repeatedly over the last half century. And yet all these judges are pretending that it's the guiding law. He does a great job of taking that apart. He does it very diplomatically, doesn't attack anybody harshly, doesn't use any over-the-top rhetoric. He just says, here's this problem, this problem, this problem, this problem, and this problem. He points out the different scholastic criticism. He points out the other, Jacobson implicitly contradicts the last 70 years of Supreme Court jurisprudence because Jacobson presumes that no strict scrutiny applies, period, because it didn't exist at the time. So there his decision is fantastic. He cites good legal scholars. He cites actual journalistic pieces that are out there. But the other thing he did is he developed a great factual record about all the nonsense about this pandemic. That look, if all you have to do is unilaterally declare something an emergency and thereby exempt yourself from the Constitution, then the judiciary doesn't exist anymore. It no longer is checking the other systems of power. The balance of power is no longer balanced in any respect. And that's where he was clearly correct. He's like, you can't just defer to a unilateral declaration of emergency. And he says, at a minimum, that should only be temporary exigent emergency for natural disasters, for to complete riots completely out of control, really extraordinary events that require 24 hours, 48 hours, 72 hours to resolve. Not 6 months, 1 year, 2 years, endless, open-ended, quote unquote, emergency measures.
The amazing thing, and if anybody, I think a lot of people have seen that previous vlog, but he basically said, like in the judgment, he says, in the depositions of the authorities, it says, well, we're still on house arrest. It's like, well, it's been suspended. And the question was, well, you could just re-implement it whenever you want. And the official says, yeah, basically. And just to illustrate what you were saying about, how the judge distinguished Jacobson, and he basically said, yeah, Jacobson was 100 years ago. In the last 100 years, the courts have developed an extensive jurisprudence about civil liberties that didn't exist at the time, and this is the standard now, not just to divert to, the father knows best type thing when it comes to the government. I was just worried that he got the levels of scrutiny wrong, but even if he did, he got it wrong the other way, and not the way that would be more favorable to the government.
Oh yeah, no, he got those clearly. Yeah, he was absolutely right about those, and he's right that really strict scrutiny should apply. But he protected himself by saying it doesn't matter what level of scrutiny applies here. The factual record, and this was key for him, is he established the factual record that they were able to avoid in all the prior decisions on the lockdown because of the way the court structured those cases, emergency injunctive cases. I was careful in the way I was structuring my cases, precisely to avoid the problem those cases got into, but also in the hopes that I would have this kind of case in the Pennsylvania judge. But those were very good lawyers up there that got it up there in front of him. And he developed a great factual record. And it was what I predicted was going to happen. Well, one, he pointed out, by the way, he says, we've never done this. People keep saying that sometime happened in the past. No, it didn't. We've never done a mass lockdown, ever. We've never done mass house arrest, ever. This has never happened in the history of American jurisprudence. It's never happened in the history of English American jurisprudence. There's no history of it anywhere in the world, in the Western world, of it ever happening. So he said, so that's a mystery. So we have extraordinary, extreme actions being taken, number one. Number two, almost all the other checks are not present because the legislative branch is not putting any check on it, because they're not meaningfully involved, either by their own choice or because the executive ignores them. And then third, pointed out that the executive did not have any good answers. That the reason why we have three different branches of government and the way we operate trials is because we know we need to have certain admissibility standards for evidence, and we need to have certain adversarial checks on the credibility and trustworthiness of that evidence. But the executive branch didn't do that at all. By having no legislative process involved, no internal administrative process that you would typically have for an executive rule. You didn't have a public comment opportunity. They put out a waiver provision and then revoked the waiver provision. Classic governors. It's like, don't worry, we'll waive it if it's too onerous. Oh, actually, there's too many people who want a waiver. Forget the waiver. This is how they work. I loved his line where he said, "This is not a white paper. These are people's lives. This is not some theoretical abstract study, But it's clear that's how all these people, and that's who controls power, particularly on the Democratic side of the aisle these days, on too much of the Republican side too, but really within the administrative functions of government, it's all these little grad student types who have no clue about the real world. And what was astounding was just how bad it was. Like, I believe that they had no evidence to back up what they were doing. And I thought as soon as we got to a trial stage, they're going to fold. And in my other cases, when I simply demanded it, they folded and gave my client what they wanted in the lockdown cases. But I was stunned at how bad it was. I mean, to not have definitions of life-threatening.
Well, so yeah, life sustaining, just so nobody calls you a name. Yeah, life. No, it's my major concern is that this will be, other courts will distinguish from this by saying, oh, the fact pattern in that was exceptional, which is why that decision stands. But in this case, they had they had a study that showed that masks were good for whatever, and therefore the mask laws are justified. Although even that is less of an invasive infringement, for example, than lockdown, than shut your business down, stay at home. So they may be able to distinguish it on a fact pattern.
But the hard part, just briefly on that, the thing is, all of those cases, I'm sure there's other, my guess is almost all these people just made decisions based on what somebody else told them, and they had no empirical information that met any degree of adversarial testing. But even if they want to put forward some, the nice thing is to subject it to adversarial testing. Because when you have journalists who lean to the left, like Alex Berenson, who was on the Hillsdale conference room table with me, saying that this all doesn't meet any evidentiary standard. He's just a journalist following the facts. And so far, almost everyone, I mean, a lot of the people on the data side criticizing what's going on are on the left politically. They didn't come at this because they, like Trump or anything else. They came at this because they're saying data doesn't support these actions. It's like, even if you had a legal right to do so, even if it could be constitutionally justified, and I'm skeptical of that, but even if you could get to that stage, this doesn't meet that standard. We have something that looks like increasingly no worse than the Asian flu or the Hong Kong flu. It's nothing like the Spanish flu, and we didn't even do this during the Spanish flu. There's no evidence any of it works, and in fact, there's plenty of evidence it doesn't work. And if there's major evidence it doesn't work or could even be counterproductive, how can you cite that as your basis to infringe, to put 200 million, 300 million people in the United States under house arrest?
It is shocking. I mean, it's shocking, and it's very much what I liked about the decision is just to say, like, this would have never been a thought in a I want to say, I'm not saying Western society, in a free society. It would never have been a thought to do this. But we had seen the images coming out of China. People, the government's got the idea, and then they saw, like, you didn't have to blowtorch doors closed in China like you saw there. All they have to do is terrify people to some extent so that they wouldn't have to use police force like they've done in Canada and the US. And then, we've seen in Australia, I did a live stream with Avi Yamini. We see what they're doing in Australia, where people, like, it's a little bit of both. Terrify them and then come down with brutal police force so that you terrify them even more to respecting all of these lockdown measures. Where do you think it goes from here? I mean, I think you mentioned it, but do you think this goes to appeal or no?
If I was the state of Pennsylvania, I would not appeal. But even though they're locked in at that point, I think they will appeal because they're arrogant. Because the other thing he pointed out too, I mean, he had such easy ammo available to him. He was completely conversant in all the discussion about the topic, which someone like Judge Barrett probably doesn't have a clue. But a judge like him did. And what I mean by that is just another illustration of that. He went into detail. He's like, look at the obvious contradictions here. There's mom and pop furniture store down the street, and he's the kind of guy to have grown up going to those kind of stores because he's a locally rooted guy. That's what I mean by the value of diverse life experience, or a certain kind of life experience, being more important to shaping your ability as a judge than your IQ test level or something like that. I want someone that has real experience, that can ground it and can understand information in a certain manner that's going to be more accurate over time than someone who's disconnected from that world. His point was, you go down to mom and pop shop, you can't go into their little furniture store, but you can go to Walmart and buy the same kind of furniture. And not only that, you're going to be in a more crowded space because everybody's forced to go to Walmart. He's like, how does this make any sense? Even if your interpretation, even if you're saying, you know what, we got to not allow people to congregate indoors, and that's why we have to shut down all these little mom and pop shops. It's like, well, then you have to shut down Walmart too. Because it makes no sense to have one open and the other closed. And so he just went through that hypocrisy, not only the obvious governor's hypocrisy you referenced, but the everyday hypocrisy that made it clear this could not have been based on empirical evidence. This was based on political choices.
Phenomenal. Now, let me just do one thing before I forget, because so there were two super chats actually that came in right at the beginning that I want to get to, just because it is a good excuse. We got not a banned account says, Mr. Barnes, what are the legal ramifications if both candidates declare themselves the presidential election winner and have parallel inaugurations? Okay. And let me see if this one was okay. This was from San Jose Mike, which said, Mr. Barnes, since you live in the U.S., what are your plans during a civil war? I don't believe that that's coming, but that will erupt when the Dems steal the election. Those may or may not have been questions that are actually that people want real answer. I think they're point questions. Yeah. Okay. No more questions on the Pennsylvania. I think I think we've covered that. It's the judge is
one of the greatest all-time decisions in American legal history.
No, I mean, that was my prediction. I hope I look smart in 10 years. But although I think I'm in good company, Robert, and I'm being influenced properly, I think, on the substantive issues. I can't believe the judge was 41 years old. I mean, that's what I read the decision, had no idea it was a Trump judge, and had no idea the guy, he's my age. And it's not that I think lowly of myself, but reading that decision would never have envisioned it coming out of someone with hair darker than mine.
Well, it's the advantage of, having a local middle class hometown guy who was really smart, who wanted to be on the bench for the right reasons. And he's one of the, Trump's appointees split, half of them great, half of them mediocre. He was one of the great ones.